Washington Legal Foundation's webinar program. My name is Glenn Lamby. I'm Chief Counsel of the Foundation's Legal Studies Division. For those of you not familiar with the Foundation, we are in our 40th year of free enterprise advocacy and education through a wide variety of vehicles. We started out as a litigating group 40 years ago. That is still our core function. In addition to filing briefs in the U.S. Supreme Court and the lower federal courts and state courts, we also are very active in the regulatory space as well. We also have our Legal Studies Division, which I'm proud to be Chief Counsel of, which is our think tank and publishing side. We also try to affect policy and educate policymakers through programs such as this and our media briefing series, as well as our blog, the WF Legal Pulse, and we're also very active on social media. This is an area of the Foreign Corrupt Practices Act that we've been active in for as long as we've been around. Our litigating side probably has not been quite as active as our publishing side, simply because there's not a whole lot of action in the federal courts when it comes to the Foreign Corrupt Practices Act. The last brief that we filed was in the Eskenazi case supporting the Supreme Court petition in 2014 in a case involving the definition of the foreign official. Both of our speakers today have participated in our legal studies program, writing papers for us on these issues. Most recently, Lucinda did write for us on a case involving Anheuser-Busch InBev that's available on our website. The passage of the Foreign Corrupt Practices Act in 1977 set in motion 40 years of change in how nations around the world address corruption. International organizations such as the Organization for Economic Cooperation and Development, the Organization of American States, and the World Bank have also developed programs to spotlight and reduce government corruption that creates advantages for certain businesses. One thing that hasn't changed, however, in these 4 decades is concern over the sweeping breadth of the FCPA's statutory language and its impact on U.S. commerce. For instance, just 3 years after the FCPA's passage, President Carter's U.S. Department of Commerce and U.S. Trade Representative reported to Congress that the law inhibits foreign exports because, quote, what conduct is prohibited and not prohibited is often unclear, and such uncertainty has caused some exporters to, quote, forego any transactions where the FCPA could be at issue. 1981 GAO report, based on a survey of 250 companies, stated the law's provisions were, quote, vague and ambiguous. And a noted private practitioner wrote in 1982 that the FCPA's inconsistent enforcement left business and their attorneys at the mercy, quote, of a government of men and women rather than a government of law. Such persistent concerns will be discussed today by our 2 highly respected and experienced FCPA practitioners. They will also offer some lessons from recent FCPA settlements and actions and underscore the need for judicial oversight of DOJ and SEC actions by noting how some enforcement might be vulnerable to challenge. You'll be able to ask questions of our speakers today using a Q&A platform that's available to the right of the viewing screen on your website there. I wanted to introduce our speakers in the order in which they'll do their presentation. Homer Moyer is a member of Miller & Chevalier in the firm's Washington, D.C. office. Mr. Moyer is regarded as one of the country's leading Foreign Corrupt Practices Act lawyers. He is past chair of the Section of International Law of the American Bar Association and was the first chair of the Anti-Corruption Committee of the International Bar Association. Mr. Moyer served as an FCPA independent compliance monitor and has chaired more than 30 anti-corruption conferences in the United States and Europe. Following him will be Lucinda Lowe, who's a partner with Steptoe & Johnson, also in its Washington, D.C. office. She is a member of the firm's management committee and head of the Compliance, Investigations, Trade, and Enforcement Department. Ms. Lowe's practice focuses on U.S. and international anti-corruption laws, advising clients on matters ranging from preventative work to representation in internal investigations and enforcement matters. She is on the board of directors of Transparency International USA, now known as the Coalition for Integrity, and also a member of the Secretary of State's Advisory Committee on International Law. Homer, could you get us started?
Glenn, thank you very much. It's a pleasure to be here today to share the dais with Lucinda and to mark the 40th anniversary of the Foreign Corrupt Practices Act. I would like to begin by noting a couple of dramatic differences between the world of anti-corruption law in 1977, when the FCPA was adopted, and today. And the first of those is that today, the FCPA is a grandfather. Now, what do I mean by that? I mean that this law spawned, ultimately, a number of international conventions, and then in turn national laws in more than 150 countries that are committed to adopting laws similar to the US FCPA. Now, this is unusual for a number of reasons. In 1977, the FCPA was a unique unilateral statute, the only statute of its type anywhere in the world. That made it quite controversial. In the 70s and the 80s, having a unilateral US statute affecting international trade and commerce was quite controversial. In some situations, other countries went so far as to enact blocking statutes to prevent their companies from complying with extraterritorial and aggressive US trade statutes. And of course, US companies at this time made the obvious point that having a unilateral statute put them at a competitive disadvantage with other countries in the world that did not have similar laws and whose companies could pay bribes to foreign officials with impunity. But what happened in the years after that was truly remarkable. In 1988, the Congress made some amendments to the statute and called on the White House to negotiate international conventions. And in 1996, a bit to our surprise, agreement was reached on the first such convention, the OAS Convention. And then in 1997 and 98 and 99, 3 more conventions followed. And in 2003, the UN Convention, which is the broadest and most ambitious of all of the conventions, and now has more than 150 countries that are signatories to that particular convention. In the words of an English lawyer friend of mine, this resulted in convention congestion. But what it really did was create an international anti-corruption legal framework that had not existed before. Following that was the process of implementation in national laws, a bit slow and uneven, and now increasing enforcement by a number of countries around the world. It so happens that as of today, the largest case of transborder official corruption is not a US case, it's a case in Brazil. So that is quite an unusual story for a unilateral US statute. Second, our understanding and views on the subject of official corruption have changed quite dramatically in the 40 years since the law was adopted. In 1977, this law came about as a result of revelations of fairly widespread payment of bribes to foreign officials by US companies. That was a serendipitous discovery. It was accidentally discovered during the course of Watergate investigations. And the concerns at that time were that this was improper because payments were being made from off-book accounts and therefore in violation of US securities laws and disclosure laws. That these disclosures, when they were made, had the effect of destabilizing governments that were friendly to the United States. And third, many people thought this was wrong and it was morally wrong. And others thought that was a naive or even quixotic notion at the time. Today, our understanding of official corruption and its consequences is really quite different. Not only do bribes violate securities laws and threaten to destabilize governments, but for the countries in which the corrupt activities take place, it is quite obviously a high level of grand theft by senior officials in those countries from their own citizenry. And official corruption imposes huge costs on the citizens of those countries. They pay more for the goods and services that they acquire. It operates effectively as a tax on them. And often these countries are resource rich but otherwise impoverished, in part because of corrupt practices. Moreover, the payment of bribes nullifies market forces. It can nullify and defeat the competitive benefits of an open and free competitive market. If you like Adam Smith and open markets, you should like anti-corruption laws, because corruption is a market distorting phenomenon. We've also come to realize the extent to which official corruption facilitates other crimes, international crimes, arguably crimes as or more serious than corruption itself. Human trafficking, drug trade, arms smuggling, illegal immigration. All of these cross-border crimes are frequently facilitated by corrupt payments to officials. And perhaps most recently, we have come to the realization that official corruption is a fundamental threat to the rule of law. We have seen this in countries that have been in transition, that have been seeking to establish rule of law-based societies. Well, if those countries have significant official corruption, it can undermine those rule of law objectives in each branch of the government. So I think today we have a much broader sense of the pernicious consequences of official corruption. And we also have a quite different level of public appreciation of those factors. As you know, there have been public demonstrations about official corruption in many countries, Russia, Venezuela, others. A constant theme of the Arab Spring was public disgust with official corruption. And it has resulted in the ousting of heads of state in many countries, Guatemala, Slovenia, many others, Brazil certainly. So this issue is no longer seen so much as simply greasing the wheels of commerce or just a matter of morality. Instead, its implications are far-reaching for international commerce, for trade and investment, for economic development, for poverty, for the rule of law. So this is really a very different subject than it was or was perceived to be in 1977. So what's happened with the FCPA over the last 40 years? I'll mention three things, and I'm sure Lucinda will add to that list and elaborate. First, enforcement has escalated. Penalties have both increased, and the types of penalties have also multiplied. The jurisdictional reach of the statute and the scope of some of its substantive prohibitions have been expanded. And in a few instances, arguably expanded to the point that enforcement authorities may be vulnerable to legal challenges on some of particular legal points and applications of the law. So let me say a brief word on each of those 3 points. First, enforcement. After a relatively slow start, enforcement has escalated, and it has escalated on more or less a straight upward trend line since the mid-1990s. The size of fines in that time has increased 30 to 40-fold. In the mid-1990s, the tipping point case in many respects was against Lockheed, in which the fine was $25 million, seen as quite a large fine at the time. For a number of years, the high water mark was at $44 million. Today, the highest fines are in hundreds of millions of dollars. Indeed, there have been recent cases in which the total penalties have been in the billions of dollars. And the types of penalties have also proliferated. We still have fines and injunctions and imprisonment, but we have penalties that were not applied certainly in the 70s and the 80s and the early 90s. Prominent among them is disgorgement of profits. In addition to a fine, a company may be required to disgorge its ill-gotten gains as a result of its unlawful behavior. This is a potentially enormously powerful tool and sanction depending on the circumstances. We today even have cases in which a prosecution is declined, but disgorgement is required nonetheless. We also have deferred prosecution agreements and non-prosecution agreements, DPAs, NPAs, which carry with them effectively a probationary period, which is yet another phenomenon. We have in many settlements, and this is not new, mandatory compliance obligations, which are not found in the statute anywhere, but which are a condition of settlement. We have, as it has been widely publicized, independent compliance monitors. Certainly, the companies that are required to retain monitors view them as punitive, certainly in some respects. We have debarment, and we have cross-debarment. And we have something under the pilot program that could also be considered a penalty, which is the imposition of a higher penalty for failing to disclose voluntarily a violation. There are regulatory statutes that have mandatory reporting obligations. The FCPA is not one of those, so that's an extra statutory dynamic. And there are other enforcement trends with which I think we're all familiar. There has been a sea change in the number of cases involving vicarious liability, and by that I mean cases in which a company's liability is generated by the conduct of a third party that the company has retained to act in its behalf. This has always been in the statute, and for years we talked about it before there were any such cases. But if you look at recent cases, the overwhelming majority of those involve third parties and involve vicarious liability. There are many cases, many large cases, indeed a majority of the 10 largest FCPA cases in history that have been brought against non-U.S. corporations that are subject to U.S. jurisdiction by virtue of being issuers. And finally, there is a much publicized emphasis on the prosecution of individuals. Enforcement agencies have concluded, not irrationally I think, that individual sanctions may be a bigger attention getter for corporations than penalties against the companies themselves. So that's one set of trends over the last 40 years. The second, both the jurisdictional and substantive reach of this statute have been expanded. Now, this is inherently an extraterritorial statute. Applies to U.S. companies anywhere in the world. And by applying to issuers, it applies to many, many foreign corporations that engage in securities transactions in the United States. Now, the jurisdiction of the statute was statutorily expanded in 1988 with the addition of what's known as DD3 of the statute. And that did a couple of things. It eliminated for U.S. companies any requirement of a nexus with U.S. commerce. They could face liability by virtue of their nationality. And second, it extended U.S. jurisdiction to any foreign corporation that paid a bribe where any part of that bribe transaction occurred within the United States. And enforcers, in addition to these changes, have aggressively construed and applied the statute. And let me give you a couple of examples. In 1988, the the knowledge standard of the statute was changed from a reason to know test, this is for vicarious liability, to a somewhat complicated two-part definition of knowledge, which in truth is applied very much like a reason to know test. The agencies have also narrowly construed at least one of the affirmative defenses, which is that conduct is not prohibited if it is lawful under the written laws and regulations of the country where the actions occur. And finally, the SEC, in construing the phrase internal accounting controls, has from time to time basically read out of that phrase the word accounting and applied it to internal controls more broadly. So let me end on a slightly provocative note and ask where, if anywhere, these agencies might be vulnerable to legal challenge, as rare as legal challenges have been historically, as Glenn noted. U.S. agencies have already lost a couple of cases with respect to the statute of limitations. I would litigate the meaning of internal accounting controls in any appropriate case because I think that is a clear overreach in terms of applying the statute. There's also, and I apologize for these legal points, but that's where we are at this phase of the discussion. There is in DD3, the new provision that broadly extends jurisdiction to foreign corporations. There's statutory language that applies that jurisdiction, extends it to situations in which a person committing a bribe takes some action while in the territory of the United States. That language invites the question whether an email to the United States or the flow of funds from one bank to another through the United States qualifies as an act by a person committing a bribe while, quote, in the territory of the United States. And finally, does the substantive reach of one of the Act's prohibitions, which on its face extends to employees, foreign directors of a U.S. corporation, a domestic concern or otherwise, outside of the United States. Is that a situation in which the substantive reach of the statute extends beyond the personal jurisdictional reach of the statute? Yet another question that has not been directly answered. So with that, let me conclude. Please send your answers to those questions to us and not the enforcement agencies.
Thank you.
Let me say at the outset that it's a pleasure to be here. Thanks to Glenn and the Washington Legal Foundation for this opportunity to talk about the FCPA. And as Homer said, it's a pleasure to be exploring these topics together. So Homer's given you some historical context and talked about some of the ways that this statute has expanded over the years, as well as the growth and enforcement. I'm going to talk about some lessons from some recent settlements, but I'd like also to provide my perspective on the statute, its enforcement, and where it's going. As has been noted, the FCPA is 40 years old this year, but the last 20 years, I think it's fair to say, have been very different from the first 20. The first 20 years featured an initial wave of enforcement, some first-generation compliance efforts, and then we had a very quiet period in the 1980s. Homer's alluded to the changes to the statute in 1988, which were not trivial, but really were designed to clarify it in some key respects. But it's really been in the last 20 years that the FCPA has taken off. So perhaps 40 is the new 20. In certain ways. Homer mentioned the Lockheed II case in the to late 1990s. And not only was that the first multi-million-dollar corporate fine, which was significant, but it also represented the first time anyone had gone to jail. Any individual had been incarcerated for FCPA offenses. And that really unleashed a new era of enforcement that has been fueled, in my judgment, by a number of factors. And it's important to note those as we think about the future. Homer's mentioned the new international architecture that's grown up around this area of bribery and corruption. Really remarkable developments in a relatively short period of time. And that's had the effect, to be sure, of increasing international cooperation in making referrals from one country to another, in investigations and enforcement. And there is no greater enforcer today than the Brazilians with the Lava Jato case. So no question that the international landscape and the dramatic changes there are having an impact. But there's more. We had corporate governance changes in the wake of the Enron scandal that brought us Sarbanes-Oxley and changed the dynamic, especially in major companies and boardrooms around this issue. We've seen increased whistleblower incentives through both SOX and the Dodd-Frank legislation, and an uptick, a very significant uptick, in whistleblower activity, particularly in the wake of Dodd-Frank. We see enforcement feeding enforcement in multiple ways, what I call following the breadcrumbs. One investigation reveals conduct by someone other than the target that may lead to another company being investigated and prosecuted. Or industry sweeps, where conduct is identified in one sector and then it's tested out in other sectors. And of course, the world has gotten smaller in many ways, which makes it much more likely today that issues will come to the fore. Communications have increased the rapidity with which information can be transferred. We have an activist press in many countries. It sometimes is a component of a more democratic and open society that can also bring these issues to the fore. So the dynamic around these issues has changed dramatically. And as I said, these not only explain, I think, the growth in enforcement, but they also are worth thinking about as we look to the future. Now, Homer's made some observations about the statute. What I would say about the FCPA is that there is no other statute, both on its face and as applied by the enforcement authorities, that cuts across so many areas, types, and stages of business activity. Whether you're establishing a business, operating a business, or even winding up a business abroad, whether you're engaged in trade or investment activity or financing. Unlike competition law, it's not just a sales and marketing issue, although getting contracts is certainly very central to the statute. But the statute has been interpreted to cover any improper influence in interactions with government that can be traced back to a tangible financial benefit for a company. And that can mean all branches of government, legislative, executive, judicial, and therefore cuts across all sorts of corporate functions. Everybody has to deal with tax authorities in a foreign country. Or if you're moving goods or people, export, import, immigration, procurement, supply chain, finance, even HR, as we've seen in some recent cases. So the breadth of this statute in terms of its impact on business activity is huge. And of course, we have both corporate and individual liability. Homer alluded to that. We also have very challenging questions of when are parents responsible for the conduct of subsidiaries, particularly foreign subsidiaries. Now, for issuers who are subject to SEC authority, there is a responsibility that comes on the parent for the consolidated group, including a remote foreign subsidiary whose economic contributions may not be material in a financial sense. And given the way the modern multinational company operates, it's much less likely that that remote foreign subsidiary is going to be operated in isolation today. So this statute does have a big footprint. And it's not all due to regulatory interpretations. The statute is very broadly written. Its jurisdictional reach, as Homer mentioned, was expanded very significantly in the last round of amendments, and that was over both U.S. and non-U.S. persons. And in the few cases that have been litigated over the years, generally by individuals, the courts have tended to adopt broad interpretations of key elements of the statute. The Kay case, in which my own firm was involved, was a case in which the Fifth Circuit held in 2005 that the statute covered bribes paid to customs officials to try to get lower import duties. So it wasn't a contract, it wasn't a concession, but it really was an operational issue. And they grounded that ruling both in the statute and in the international architecture that has been referenced earlier. Eskenazi, which Glenn mentioned in the introduction, a decision of the 11th Circuit in 2014, the first interpretation of a central term of the statute, the term foreign official, in that case as it was applied to personnel of state enterprises or government instrumentalities. Again, we had judicial interpretation of a statutory term that was grounded both in the statute and in the U.S.'s international obligations under the OECD Convention in particular. So the breadth comes in part from the law itself, but some of it is the result of interpretation by enforcement authorities as well. And we have in this area, as you all know, two key enforcement authorities, the Department of Justice and the SEC. Homer and I are in agreement that one of the more striking ones is the way the concept of internal accounting controls had been taken both by the SEC and by the DOJ from something that many of us thought at the beginning was very specific and narrow, and has really been leveraged into compliance expectations that often have nothing to do with accounting or financial transactions as we would normally think of it. For example, hiring processes followed by HR. Or in the SEC settlement in the AB InBev case in 2016, which Glenn mentioned, where the parent company was held responsible for the oversight failures of a subsidiary in India that was a member of its consolidated group, but that responsibility applied to the conduct of a joint venture, minority joint venture, in which that subsidiary was a shareholder. Just to state that gives you a sense of the breadth of those concepts. And there are other things that facilitate this extensive enforcement and broad approach to interpretation. The use of tools that allow for multiple forms of resolution, not just pleas, but have been, as have been mentioned, deferred prosecution agreements, non-prosecution agreements are used with more frequency in this area than many other areas. But you also have the reluctance of corporate boards to litigate, which can empower enforcement authorities. And the courts, while they have to approve certain forms of resolution, there are only some forms of resolution. And if you look around the world and compare the picture to, for example, the United Kingdom, there's a lower degree of scrutiny here of those negotiated resolutions than you have in some other countries. And we have in our system as well an historic degree of prosecutorial discretion that goes beyond plea bargaining and extends to whether to charge somebody, what to charge, and how you calculate the penalties. So all of those things are facilitative of enforcement. Now, where are we going in the next 10 years? Well, I view the FCPA, despite its middle-aged existence, in many ways as still a relatively young statute with an enforcement system that is still maturing. In the early years, we had sometimes not even one case a year, and that's not enough of a stream to really systematize an enforcement program. There has been a lot more experience in recent years with the higher enforcement volume, and that, I think, has given both the SEC and the Department of Justice an opportunity to try to systematize more how they're approaching these issues. I'd like to present a few questions that I think need to be thought about as we contemplate this next stage. We've just talked about the breadth of the statute, the wide range of conduct that it applies to. And arguably all of it has the distortive effects at one level or another that Homer's described. But I think it's also fair to say that some effects are worse than others. You have grand corruption, the getting of major contracts that can impose these costs throughout society, versus petty corruption that may be much more localized, much more small scale. You have isolated instances of corruption versus really systemic instances. And you have corruption that may be just for a business advantage or is linked to other things. It can be anti-competitive, it can undermine national security, and ideally an enforcement system would identify and prioritize those things and make some distinctions among them. Ideally as well, I think the system would look at corporate responsibility in terms of root causes. Is this a rogue or has the corporation really engaged in good faith, significant efforts to self-police? Ideally, you'd have a system that would treat similar conduct similarly and be transparent and proportionate as to penalties. Ideally, you'd have a system that would strike the right balance between individual and corporate liability and that wouldn't pile on, either domestically or internationally. Now, I think the enforcement authorities have tried to move to a system that prioritizes at least some of these things. And if you look at recent cases, you can be struck by the number of grand corruption cases, whether it's the Uzbekistan telecoms cases or the Brazilian cases or others. And jurisdiction is aggressive in a number of cases, but probably more often against foreign nationals, as the statute, as Homer indicated, gives broad jurisdictional reach over U.S. persons. This may be a good thing, actually, from the standpoint of leveling the playing field and preventing impunity in a world where foreign enforcement is still spotty. I agree with Homer that penalties are an issue that merits some attention. It's an area where the enforcement authorities in the U.S. have been significantly more transparent in recent years in how they get to a particular result. But there are still substantial questions that remain. Homer mentioned the incentivization of voluntary disclosure, something that the statute doesn't require. He also mentioned disgorgement. And this is an area where I think we are going to see some real changes in the near term. Some of you may be aware that the Supreme Court last June in the Kokesh case unanimously decided that disgorgement in SEC enforcement actions that are filed in federal courts operated as a penalty and was therefore subject to the 5-year statute of limitations that federal law provides for. Now, this wasn't an FCPA case, but it didn't matter. It applies to all areas where the SEC has enforcement authority. And indeed, recently, SEC officials such as Steve Paikin, who's the co-director of enforcement, has noted that this decision may have a particular impact on FCPA cases. The complexity of these cases, the length of time that may pass before conduct comes out and an investigation is completed means that they may be bumping up against the statute of limitations in many cases. And for the SEC, unlike the Department of Justice, you don't toll the statute of limitations when you're seeking evidence abroad. So the result of this could be a real impact on the SEC's enforcement program. Now, this may be countered by requests to companies to toll the statute of limitations. The OECD has questioned whether the U.S. statute of limitations is long enough. Compared to many countries, it's relatively short. And so I think this is an area where we're going to see a lot of impact on, particularly on the SEC side, but the question also comes up with the Department of Justice. In the recent pilot program, FCPA pilot program, that was adopted on a trial basis in 2016 and is still in effect, disgorgement is a key element of a declination. And frankly, much of the COCASH analysis could be applied to enforcement in that context as well. So I see that as an important issue. Another area where I think we need to look at what may be happening is the relationship between compliance, corporate self-policing, and enforcement actions. Now, we know that there's no compliance defense in the FCPA. This is part of the discretionary calculus right now that enforcement officials bring to bear. I think we've seen evidence that the enforcement agencies are exercising their discretion with greater frequency to decline to pursue cases where there's a strong effort at self-policing. Not all of these cases are public, but those of us who practice regularly in the field have seen them. But the problem is that this isn't transparent, and we don't really know what the full universe of enforcement matters looks like. Some of us in the field have long argued for the enforcement authorities to be more open about the totality of the universe they see in this area. Why can't we have summary statistics about how many complaints they receive, how many cases they decline each year, how many get investigated fully, et cetera? That would provide us with a full picture of what's going on in enforcement. Right now, we see the tip of the iceberg. I won't talk at this point about the relationship between individual and corporate liability. That may be a topic for questions, but I would like to say a word in closing about the challenges presented by the internationalization of the FCPA. There is no international double jeopardy rule. And as other countries adopt statutes like the FCPA and begin to enforce, what we're seeing is, because this is a statute, as has been said, that is inherently extraterritorial, the conduct touches multiple countries. And so you're going to have, in any given case, multiple countries that are interested. Now, there have been instances in the recent enforcement actions of coordination, not necessarily joint investigations, but coordinated resolutions among the enforcers. And this is a good thing. And as has been pointed out, the United States isn't taking the lead in all these cases. And there is some effort to allocate penalties. But this is still a very nascent and imperfect system where there can be piling on. You can have countries that have come in after a U.S. resolution and put the document in front of a company and said, well, sign, pay us an additional penalty. So we need to refine the international system for resolutions. And finally, at the same time, the enforcement on, let's call it the supply side, has increased against the companies and the individuals. The demand side is lagging. And we do need to look in a more concerted way about how we get countries to ensure that their officials are held to task in this area. Because until you deal with that, you're only dealing with half of the issue. So in conclusion, I would just say I don't think the FCPA is going to go away anytime soon, or that enforcement is going to necessarily abate, because I think many of the conditions that have brought us increased enforcement are going to continue. But I hope that the next decade will see a continued maturation in enforcement policies and more work on the demand side. Thank you.
Thank you, Lucinda. Again, if you have a question for either of our participants, you can ask it right there on the video platform where it says ask a private question. They will come to me and I'll present them to either one of our panelists. I'll start things off by asking about the FCPA Opinion Procedure Release Program and why that hasn't been as relied upon or utilized by those who are regulated by the FCPA.
I think a couple of reasons. Sometimes it's slow, notwithstanding the deadline. More importantly, it is limited precisely to the facts that you posit when you submit a request. So if the facts change or are a little bit different, that opinion is arguably not helpful, and they go out of their way to say it may not be relied on by other parties. But I also think a factor is that the truth is the Justice Department does not like to think of itself as a regulatory agency. It's an enforcement agency. And so it did not come naturally, I think, to the department. They're not encouraged. And so this the use has dissipated.
I agree with that, and I would say I've had many situations in practice where we've talked about whether it's a useful tool and whether we should seek an opinion. As a practical matter, because it can only be used in cases of prospective conduct. You're thinking about doing something. There are real timing constraints. You have to submit this material. They may have follow-up questions. You may have to make a decision as a company before that process can play out. And of course, companies fear, and it's partly the mentality that Homer has described, companies fear opening themselves up when they go into potentially a broader set of questions than they came in with. And they open themselves up to having another party at the table, determining not only whether something can go forward, but on what basis. As the department hasn't been shy about saying you have to have this, that, and the other safeguard in this. So it complicates a prospective transaction, and I think we now have enough experience to know that that's not likely to change.
You talk quite a bit about how frequently these cases end up settling through various ways. Has that, you think, impacted the quality of the enforcement that occurs when there aren't as many investigations that go on for long periods of time, or there may not be opportunities for SEC or DOJ employees to develop the kind of expertise beyond the sort of how do you get into the settlement proceeding? How do you think that affects the enforcement of the law and also the compliance with the law by corporate entities?
So I'll start on this one. I think generally it's a benefit to have a flexible system that gives the options that our system gives. So don't misunderstand what I'm saying from that perspective. I think if you compare our system to many other countries, the different tools we have confer advantages. The downside of the system, and there are several downsides, is that we don't have all the checks and balances in the system that you would have if there were litigation, robust oversight by the courts. And so it can lead to a situation where the other side of the table may not be as rigorous as they would otherwise have to be in in their analysis of conduct. And that, in turn, puts a real burden on counsel, who's on the other side, to push back when they think that the department or the SEC enforcement officials are going too far in their analysis of the issues. That becomes the check and balance. It can be done effectively, but there's a certain art to it. It becomes more difficult, I think, when you have rapid turnover in the enforcement agencies. We've had many cases now where the people we're dealing with at the end of the process are not the same people we have at the beginning of the process, and it becomes very hard, actually, because these cases are very fact intensive. They're very fact specific, and so I think there is a cost to this system in terms of dealing with the issues, the conduct issues that are often very nuanced and challenging.
I think it can affect the quality. It certainly affects the quantity. We've had hundreds of FCPA cases. Were one to have to litigate all of those cases, we would have a tiny fraction of the number of cases that we have. And so you see the phenomenon of other countries that do not have the plea bargaining prosecutorial discretion that U.S. prosecutors have, wanting to mimic a similar system, because you can certainly build a body of, I will call it case law, a body of cases much more rapidly with the kinds of settlements that we've had. And as you know, there have been, with one corporate exception, they're all settlements. So the downside of that is that the so-called jurisprudence that we have is not quite the jurisprudence you would have if these were court decisions. And the dynamic is such that you may have willing partners for different reasons who will acquiesce to stretching the rules. That is to say, the agencies may push a bit over the line because of the low likelihood of judicial review, and corporations may simply accept that because they want to finish this, get it out of the newspapers, and move on. So, as we both said, there are two sides to this picture.
So one of the ways, obviously, to measure the effectiveness or strength of a law is the number of enforcement actions, the number of settlements, et cetera. Are there other ways to measure how effective the FCPA has been, and is it fair to dwell so much on those kinds of outcome-oriented results and not look at how much more aware corporations and individuals that run them are now of the need to worry about complying with this kind of a law and to not fall into the trap of working the way that foreign entities would want you to work?
So, in my view, you have to have a credible enforcement system in order to incentivize compliance to the extent that you would like to have it. And I think one byproduct of the last 20 years of active enforcement, as well as the internationalization, is that corporate compliance has moved forward very significantly. This is in part an issue of culture and morality, but it's also and this is where compliance comes in, part about education and having the right set of controls. And there's a very active debate in the compliance world about, rules-based versus ethics-based, which I won't get into. But the point is that enforcement has really caused compliance standards to evolve very dramatically. Now, are we at exactly the right place? It's very expensive, and it's very, because of the breadth of this statute, maintaining an effective compliance program in this area is no small undertaking. And Although there's been a lot of convergence around the world on compliance standards, I think we're still fine-tuning what the right model and level of effort should be. But that's been a direct impact of the enforcement. We also have the internationalization of this area, and that's a very helpful thing. Back when the FCPA was a unilateral statute, unique in the world, it was very difficult for U.S. companies or companies subject to the FCPA who wanted to maintain a certain standard of conduct in their activities. So I think the internationalization, which has been very substantially influenced by the U.S. experience, is a good thing.
The ideal metric, of course, is whether there are more or fewer cases of corruption as a result of these laws and enforcement. That's an impractical metric because there's so many variables that affect it. But if you're in a private practice perspective, I mean, having seen literally hundreds of corporations react to these laws, it is indisputable that it's night and day, the difference now from a generation ago. And it's interesting to note that the tipping point really appears to be a large, well-publicized enforcement action. That was the sea change with Lockheed in the United States. That's arguably the sea change in Europe with Siemens. And it's plainly the sea change in Latin America with Lava Jato.
Question from a viewer: what is the status, if any, of starting a whistleblower program for the FCPA?
What is the status of starting?
Of starting a whistleblower program similar to, I guess, what exists for other laws that SEC enforces.
So, So under the FCPA, really, as part of your compliance program more broadly, not just in FCPA terms, companies are expected to have mechanisms for reporting concerns about conduct as well as questions, including in the United States, anonymous mechanisms if people don't feel comfortable going to their supervisors or other individuals. So that's one piece of what's expected. The laws have been clear that in addition to enabling people to report in a way that they're comfortable reporting, there shouldn't be retaliation against whistleblowers or measures to discourage those whistleblowers from going to the SEC or other enforcement authorities. In fact, that was one of the things that was at issue in the AB InBev case that we touched on earlier, was concerns from the SEC that the company had discouraged in settlement agreements with terminated personnel the possibility that these individuals could report concerns about compliance to the SEC. So the framework's pretty simple. Applying it can be more difficult.
With regards to the internationalization of the FCPA and foreign corruption enforcement, have you seen instances where U.S. companies have gone to U.S. officials and asked them to encourage foreign officials to enforce their own laws against competitors overseas that are engaging, or at least the U.S. competitor feels are engaging in corrupt activity in order to gain an advantage in the market?
Okay.
Well, multiple jurisdiction enforcement actions introduced a host of new issues and dynamics. And of course, we don't know what conversations individual companies have with enforcement officials. But all of the obvious risks, from double dipping in penalties to different procedural rules, to different rules of privilege, to different paces of investigation, to coordination on penalties. All of those are issues that are raised by parallel investigations in different jurisdictions, and some of those are quite tricky and difficult issues. Good to get ahead of that curve as quickly as possible.
In addition, and this is a slightly different dimension perhaps of your question, it can be difficult sometimes to get a foreign authority to take action against its own companies, whether or not they're national champions or for what, have connections to the regime or for whatever set of reasons. I've personally traveled to different countries from time to time on cases to try to get another country to do something. Today there is much more cooperation, I think, but there's still a problem of selective enforcement in many countries, or a lack of enforcement, particularly when a company's very politically connected to the regime. So this is an issue, and this is one of the asymmetries in the system today.
The vicarious liability that you discussed at the beginning certainly raises how difficult compliance and enforcement, even within your own supply chain and within your own companies, can be. What are some effective risk reduction strategies for addressing third-party intermediaries, which often create this kind of vicarious liability for companies?
It may be the hardest area for effective safeguards. You are at risk for the actions of a third party who's not your employee. So if you get in bed with this person, that person can get you in trouble, whether you instruct it or acquiesce in it or not. I think some safeguards, such as contract provisions, admonishing or prohibiting improper payments, are really not very effective. If someone's going to pay a bribe, they'll sign a contract that has an anti-corruption clause on page 8. But there are a number of things you can do. First is look at the business need for a third person. Is there a legitimate need? Is that person qualified professionally to do what you're asking, or is this just a fix-it intermediary? Have you done due diligence? Have you checked with references? Will the person agree to monitoring and having its books audited? All of these are risk reduction measures. There's not a silver bullet here for vicarious liability.
Yes, I just add, we have seen some companies who that have gone through enforcement issues decide that they were going to change how they did business and cut way back on their use of third parties, particularly sales representatives, marketing agents, because they viewed that as a highest risk activity. But for most companies, it's not practical to stop working with third parties entirely. And so you can, what you often need to do, just because of the sheer volume of third parties that a major company will end up dealing with, is kind of risk tier your third parties. So you may have a third party who's classified as highest risk by virtue of where they do business, what they're doing, how much you're likely to spend with them, how they're paid, whatever the risk factors are. Conversely, you may have a third party that presents very little risk, and you need to tailor your compliance measures to fit the risk profile of the third parties. Technology can be a big help in this area. There are now more tools that exist for tracking and monitoring than there used to be, but this is the single greatest risk area under the FCPA, for sure.
Talked about the amendments of 1988. Do you think there's any chance that there'll be further legislative tinkering with the FCPA anytime in the near future, and what kind of amendments do you think would be most helpful and have the greatest chance of being adopted by Congress and signed by the President?
You want to take it?
I think amending the statute is, A, politically tough. B, there is not a compelling case, I think, that can be made for that. And if there were amendments that in any significant way diluted the statute, that would be anomalous, if not embarrassing, for the United States, and I think would get a lot of opposition. The easiest response to amendments that would soften the law would be simply to say, correctly, this will make it easier to bribe foreign officials. That's not a terrific political horse to ride.
So I just say, I agree, the politics are very tricky with this issue, and because it's not a unilateral measure anymore, it's part of our international commitments. There's an additional layer that comes into play if the U.S. were to be seen as going in a direction that really cut back on the statute. Having said that, the internationalization does create some opportunities for dialogue. There are countries that have introduced a compliance defense, for instance, and I think that's a topic that should continue to be explored. The trend is away from facilitating payments, which is still an exception in name in our statute. So you could do some things in the name of an international movement. Personally, I would love to see some more dialogue around issues of successor liability from mergers and acquisitions, and also in some industries, the issue of tainted assets becomes a very big problem, where maybe back 30 years ago, there's some suspicion that there was misconduct by a predecessor in interest. And at what point, does that taint really get erased? So I think there are some issues that could benefit from some thoughtful dialogue, but it's a hard issue to tackle.
One final question. There have been a number of actions and settlements of those actions announced in the last couple of weeks against individuals under the Foreign Corrupt Practices Act. Is there anything to be learned from those particular cases, and in general, is there any sort of signal as to how this administration might look at foreign corruption and enforcement differently than the previous administration did?
Well, so I'll start out with that. The pipeline of these cases is long, and one can't infer too much on a year-to-year basis. And these were certainly cases that were in the pipeline earlier on. We have seen less in some ways than many of us expected from individual prosecutions over the last couple of years, given how much print has been devoted to this issue and policy statements by different enforcement authorities. They've had some individual successes, but I think they're still saying that for deterrence purposes, a focus on individuals is very important, and I think we need to see that very concretely. So these cases are interesting from that perspective, but I think we need to see more.
One cannot rule out some high-level political intervention, but I don't foresee significant changes. Steve Pekin and Charles Kane are not going to, I think, change the trajectory of enforcement. I think that will continue. Prosecution of individuals certainly will continue. So I don't see the softening that some people forecast might occur. And one final thought, I was just in South America talking with companies directly or indirectly affected by the Lava Jato prosecution. And the ripple effect of individual prosecutions there, of which there have been many, has really been quite extraordinary. and I think it underscores the potential impact of that policy judgment to continue going after individuals.
I think we will conclude there. Thank you both for joining us today, Homer and Lucinda. And if those of you who have joined us today online have an interest in having others see this, it will be available as an archive file on our website first thing tomorrow morning, most likely. And wish everybody happy holidays as we go forward towards them. Thank you again.
Thanks, Glenn.